The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. You may be seated. We have two cases before us today. The first case that is set for oral argument is State of Iowa versus Brenna Folkers. State is represented by Sharon Hall, and Ms. Folkers is represented by Maria Ruhtenberg. That will be heard at an oral argument in a moment. The second case that is to be submitted is State of Iowa versus Cammie Jo Scheibout, and that case will be submitted at this time without oral argument. Ms. Ruhtenberg, you may begin.
May it please the court? Counsel. Good afternoon. My name is Maria Ruhtenberg. I am here on behalf of Ms. Folkers. Today we ask the court to reverse her conviction for child endangerment because there was insufficient evidence at trial that she acted in a manner that created a substantial risk to her son's physical safety. The evidence presented at the trial was that her and her husband, Mr. Wilson, awoke to a fire in their home. Mr. Wilson had later admitted they had evacuated the home, and he later admitted that he had been smoking hash oil, marijuana, and cigarettes prior to the fire the night before. The police suspected a butane torch that was used to smoke the marijuana and the cigarettes caused the fire. The defendant, when interviewed at the hospital, admitted that she had previously, at some point in time, smoked marijuana in the home, but had not done so the night before. There was no evidence admitted at trial that she had participated in any smoking of marijuana or hash in the home prior to the fire. Police searched the home with the consent of Mr. Wilson. They found hash and marijuana in a cabinet in a bathroom attached to the master bedroom. He had
the cabinet locked or not?
Well, the evidence at trial, the way it went down is the evidence at trial was Mr. Wilson testified that they kept the cabinet locked and that they had a baby gate in the kitchen that separated the child's room from that part of the home. When the video was played, this was later on in the afternoon, or like later after the fire, and they'd gone to the hospital.
And I've watched the video, and I have a little trouble following it. That's why I asked. When
I watched the video, and I watched it recently, it's dark in there, and so it's lit up, I think, with another person's cell phone, or cell phone that somebody's walking with them. I couldn't tell that it had been locked or unlocked. It looked like it was open to me when they finally shone the video on it with the light, but I mean the video speaks for itself. There's in the record a different interpretation of that. Regardless, our position is that video doesn't necessarily represent the condition of that cabinet the night before, the week before, or any other period of time. There was also evidence presented that when the police officers arrived after the fire was called in, Ms. Folkers was in the home, and police went in to try to get her out. I don't know what she was doing in the home. Maybe she was trying to get the drugs out. I don't know. But certainly there was a lot of activity in that residence from the time that Mr. Wilson admitted to smoking marijuana and hash in the home at like 7 or 8 the night before. So,
what can you clarify what's in the record exactly? So we have the DVDs that were admitted into the record, but as you're reading the trial transcript, the prosecutor says, well, I'm going to play this but without sound because it contains a lot of statements from Mr. Wilson. I think that's his name. Is that
yes.
Correct? As he's kind of narrating things. So is the video, the visual part of the DVD, is that what was admitted, or are we free to consider kind of all of his narration and comments that he makes about hash use, etc.?
When I recently watched the video, there was a lot on that thumb drive, and I was able to find a video, and it did not have sound. But it took me a while to figure out which file there was that I was supposed to look at to play.
That's a complaint that I want to take up with what they did below, that they call it Exhibit A, and it's a whole bunch of things. And it should have been maybe admitted separately as separate items, because it makes it hard for us to follow a little bit what happened below.
Yeah, and I don't know what he said, because whatever video I watched, there wasn't any sound. And the record does indicate that what was admitted was without sound. And
it says he was going to play it, but then turn off the volume. And every video I watched had sound.
Okay.
Just so you know. So I'm not clear exactly if there was I didn't see any stipulation that this was being admitted, and because of hearsay problems, we were just going to show the video and the judge wasn't going to consider the sound. But everything that I saw that had Mr. Wilson on it had sound.
It had sound, and it had the husband talking throughout, so I could see why it might have been made. The decision might have been made to admit it without the sound, because the husband talking would have been hearsay.
That was my understanding. I could go back and look at the record and see exactly when it was admitted. Because what I said, I recently watched it. I was wondering if there was something on my end that I wasn't getting the sound, so I went back and looked at the record, and it says it was without sound. So I'm like, okay. So that's my understanding, is that the sound is not part of the record.
I want to make sure I understand this correct. Dad used a butane torch to light a blunt, or whatever you want to call it, with hashish oil on it, and it sounds like that was the source of the fire, according to the record. Would that be a correct summary regarding Dad?
Regarding Dad, he testified that he had used that torch to smoke, I think it was a marijuana cigarette, at some point in the evening, maybe around midnight, and then later had used it to smoke a cigarette. And wasn't that going to apparently the cause of the fire? At least the record. I don't think that was ever explained. I think that's sort of the assumption that it was the torch that started the fire, because the fire in the area, it was really the only thing there.
Okay, if that's the only thing we were talking about, would you say that is child endangerment by Dad?
I think, and I don't know. The record indicates he did plead guilty to child endangerment and reckless use of fire. The record doesn't say if the child endangerment was based on his reckless use of fire or his drug use.
I'm just trying to get you, I want to talk about one more point beyond this, but would you agree with me that would be a pretty clear case of child endangerment if it unfolded that way?
Yeah. I think
there would have been drugs in the house. He was using a torch to light it. There was a fire. Kids in the house.
The reckless use of fire with people in the house if the state could show that he did something reckless with that fire, I think, that could be a child endangerment.
So now the distinction of your argument is, but don't make Mom responsible for that, because she isn't the one at that moment on that evening that smoked a joint or used the butane lighter. Would that be correct?
Well, I think there's a difference between using a lighter, and the last thing he testified to that he used the lighter for was a cigarette. So as far as if he was reckless in using the torch for whatever purpose, I think that could possibly be a factual basis for a child endangerment. With regard to smoking drugs, I think that's a different question. And below, the Court of Appeals did not find that the smoking or that the defendant allowing smoking to happen in the home was the basis.
Isn't this a case of credibility? Wasn't there quite a bit of credibility discussed in the Court of Appeals opinion as well, that it boiled down to more credible evidence?
The Court of Appeals found that the video that we were talking about with regard to the baby gate was contradicted the father's testimony. And the way that was presented at trial, he testified, and then the video was played. And there really wasn't a fleshing out of that. Why was the baby gate gone? Was the cabinet really locked or not? Like I said, there was a fire. Who knows what happened to that baby gate if it was there while the child was asleep. The video also shows a toddler slept in a crib. So I think there was more to the story. But yeah, the Court of Appeals just found that the video of the fact that there wasn't a baby gate to contradict Mr. Wilson's testimony that there was a baby gate.
Would smoking marijuana in the house while the child was present be sufficient in and of itself to satisfy the endangerment statute?
I think there are cases getting close to that. There's one of the cases cited had to do with people smoking methamphetamine and the child being in the next room of an apartment. The child was injured in that case, and so it's a little bit different. I think it's a closer call, but as the Court of Appeals stated, there wasn't any evidence presented in this case that my client smoked any marijuana in the home when the child was there.
It looks like, am I correct from reviewing the record below, that the case was tried on the theory that the child endangerment on her part consisted of having the child in the house where the drugs were kind of easily accessible even to a toddler? Isn't that really what the theory was? Not so much the fire that they didn't lay on her for purposes of the trial. Am I correct?
Yes, there was quite a bit of testimony surrounding the fire and the cause of the fire, but at the end of the day, that was the theory, that she allowed her or didn't stop Mr. Wilson from using drugs, and that she had previously used marijuana in the home. There wasn't a lot of fleshing out of the child being present or not. And then also, yes, the fact that the drugs were in the...
Was the Court of Appeals correct to conclude, quote, keeping marijuana and hash oil in the home where a toddler can access it creates a substantial risk to the child's safety?
Well, I think
page 3.
Yeah, I think the key to that is where the toddler can access it. You can analogize to other items of things being kept in the home that can be dangerous to children. And, cleaning supplies or something like that left in a cabinet that doesn't have a baby lock on it, is that in and of itself just right, a child lives there with that, is that child endangerment? Our position that there needs to be something more. There needs to be something that the child was actually in the vicinity, actually did access that.
Isn't that's kind of what I was getting at with the credibility determinations. I think that was so important at the lower level, that the lock, there is some evidence that did not appear to be in place, that the baby gate, all of those arguments you just made about access being key, wasn't that addressed, and could that be perhaps why the scales were tipped?
Well, I think there wasn't evidence that there wasn't a lock on the cabinet. There was just evidence that at the time of that video, that it was opened or opened at some point. So we don't know if there was in fact a lock on there other than what Mr. Wilson testified to. There was nothing to contradict that. There's nothing to contradict his testimony that they kept it locked. I mean, this is a fire that happened at 6 o'clock in the morning. The child's asleep in a toddler bed. I don't know if they kept the baby gate up when the child is asleep in the crib or not. But I think that there was not a whole lot of testimony or evidence presented by the state to contradict what he said. There wasn't any. It was just a video. And that is that point in time after the fire.
Was there any evidence by mom? I think it'd be a more persuasive argument if mom had tried to remove herself or the child from that environment, if she had taken any steps for protection or otherwise. But it seems to me instead, not only did she not, there's no evidence that she tried to remove herself or the child from that dangerous environment, but she also would participate in the illegal drug activity. Maybe not at that moment, but in general, she acknowledged she did, correct?
We don't know from the record what she knew at the time, if she was asleep, if she was awake. Some of his drug use he admitted to was like at midnight. He was up using that butane torch, smoking a cigarette at 2 in the morning. So I don't think that there is anything that the state presented that would show that she had the obligation or knew what was happening to go and, make him leave or call the police or remove the child. So that wasn't fleshed out, so we don't have that evidence.
Wasn't there a part in the DVD, one of the clips, where he says that he and his wife smoked in the bathroom at around midnight?
Not in the record. That I didn't get the video. I didn't get the audio of the clips. The only audio...
If that was admitted and there's no record indicating that the audio was inadmissible, and if he says on one of the DVDs that they smoked at midnight in the bathroom, would that be sufficient to sustain the conviction?
The evidence at trial, it's my understanding that those DVDs were admitted without audio. And the finding from the court was that there wasn't evidence that she had smoked anything, any illegal drugs.
Ever or at that moment?
No, at that moment, at that night.
Okay.
That night.
I want to take that a little step further. So let's say we have a couple that's pretty smart and they decide on odd days he's going to smoke the illegal drugs and on even days she will. And then it just depends on when they get busted. Does that mean we aren't going to look at the general environment of the child? Are we only going to look at who we can bust for that moment? Because I'm looking at it more generally, if there had been drugs in the home, whether he smoked that night or she did. I thought the record was pretty clear that they both engaged in illegal drug activity.
There was, as the Court of Appeals found, yes, she did admit that she had smoked marijuana in the house or in the residence before, but there was no evidence presented that she had custody, care, control, the child was present at the time. So I think that, regardless of who's being charged or what, there has to be some proof that not just in general, theoretically, at some point in time, the mother had done this. I think we need to have some proof that she knowingly put her child in danger of risk of injury at the time that she was smoking. So I think it has to be a little bit more evidence than that. Thank you.
Thank you. And Ms. Hall.
May it please the court and counsel. I'd like to first start with the Court of Appeals opinion and point out that it fails to include a number of the material facts found by the district court that further supported the defendant's guilt. First, on the facts, there was no mention by the Court of Appeals of the 1.5-foot tall butane torch found on the kitchen counter, which was the apparent cause of the fire on the kitchen floor. Nor is there any mention in the opinion of the fact that Wilson, the husband and father, admitted to using the torch to smoke hash oil twice that evening in the master bathroom at 7 p.m. and again at midnight, and then to using the torch to light his cigarette at 2 a.m. out in the kitchen before going to bed. The child's bedroom in the record states that it's towards the front of the trailer near the kitchen. The district court found that Folkers had admitted to using marijuana and hash oil herself, just not that evening. But she admitted to knowing that Wilson had smoked hash oil that evening, presumably at least once before she went to bed. Thus, it's reasonable to infer that she knows Wilson regularly smokes controlled substances in their small trailer and often uses the torch as a lighter, a practice that seems dangerous in itself. The district court noted Officer Roberts' testimony that hash oil is a flammable substance. The officer further testified that the extraction of hash oil from marijuana leaves using butane is a highly flammable process. It's not a stretch to infer that having the butane torch in your house could be a possible use for that. Although we don't have a lot of expert testimony in this case, the officers did testify that hash oil has a higher THC concentration than marijuana. The defendant admittedly has personal experience as to the effects of smoking hash oil on herself and her husband's behaviors. Wilson also admitted to drinking most of that.
Was there any evidence in the record about what that effect was of smoking the marijuana on either one of the parents or smoking the hash oil?
There's no expert testimony on the exact effects other than it's substantially stronger than just smoking marijuana alone.
Well, is it your position then that if a parent smokes marijuana and a child is present, that is per se endangerment?
No, that's not the state's argument.
Right. So, to build on that, you're suggesting that the hash oil, which has a flammable feature, combined with this torch, now we're getting into a potentially incendiary posture, and that gives rise to child endangerment. I take it. Do I understand your position?
Yes, our argument is that the totality of the circumstances in this case, the state's theory of prosecution was not solely based on the mere presence of controlled substances that were potentially accessible, or even just the act of smoking in the home, but it was all of the circumstances.
How about hash oil? I mean, supposing, I'm showing my ignorance, I guess. The hash oil is used in combination with the marijuana.
I think the hash oil is, at least from my Google search, extracted
Right.
by using the butane fuel.
right.
So then it becomes they
So-
described it as a dark, sticky substance.
Right. Someone who uses hash oil in the presence of a child, is that child endangerment?
I don't know what type of, I would assume it's like vaping, and I don't know what type of.
The record maybe doesn't support it in this case. So, without the, what I'll call the incendiary features of this case, it might look different, right?
It might be different if there was no discussion of using the torch for.
I mean, kind of to cut to the chase, if we took the hash oil out of the scene and it was just marijuana being used in the trailer by Mr. Wilson and being stored in the trailer, would that really be enough to be child endangerment?
Just the smoking marijuana? It could be. It just depends on what other facts. Yeah.
Child endangerment by Miss Folkers or by Mr. Wilson?
By the mother. Our theory is that she clearly knew they had several bags of marijuana.
So it's your position that a parent who was not herself at the time smoking marijuana or doing any illegal drugs, if she just allows someone else to be in the home doing some type of illegal drugs while the child is asleep and not in the area, that's enough for child endangerment for the mom?
It may be, and it has been enough in some of this court and the Court of Appeals.
That's what I was going to ask you. What cases support, especially specifically related to marijuana as opposed to methamphetamine? Because the cases addressing meth also included, as I recall, expert testimony about the effects of meth, which are, as I understand, quite significantly different than marijuana.
That is correct. This record does not have that type of expert testimony. And the pedatory Jane's case both involve methamphetamine, and there is some expert testimony about the effects on persons, increases the danger of children being around. The Mask case involves smoking marijuana in the apartment. There were bags of marijuana on the table, loose crack cocaine as well, even though...
There were also razor blades and scissors on the kitchen table. Is that right, in that case? In the Mask case?
I'm not sure I remember those specific facts. The defendant had claimed that the toddlers were not present in the room when actual smoking occurred. But I think if you're going to argue just accessibility, it needs to be, you need to have more facts showing how readily accessible it is. And on those points with the cabinet being locked, we do have officers' testimony, the one that was walking through the trailer with Mr. Wilson, and he said that Wilson opened the cabinet. It was not locked. So I don't recall from viewing the video clips months ago that if there was a locking mechanism, Wilson certainly didn't lock it after he used hash oil the second time around midnight.
Can you clarify the issue of what is actually in the record and whether or not the audio with Mr. Wilson walking around the trailer and the audio of him in the hospital, whether that's part of the record for us to consider?
There were 3 discs. Disc number 1 and 2 are statements the defendant made to officers while she was in the hospital. The disc number 3 is Wilson and the officers walking through the trailer and showing video and that. I don't specifically recall sound. My notes don't indicate whether I listened to any sound on it.
I guess I'm not sure what I was looking at then, because the DVDs I looked at, one of them had 5 different clips on it, and it had all kinds of...
I think in the briefs there's specific time notations as to exactly what they thought was being admitted. There's like 7:39 something to...
Wouldn't it be easier to edit it and
the DVDs we have, there's three DVDs, one exhibit, and then each DVD is multiple files, And then there's on one of the, I think it's the third DVD, Mr. Wilson kind of takes the officers on a tour through the trailer, and he's talking. So, maybe we have something different than the parties do. I don't know.
I just don't remember it. It was that many months ago.
If you look at just the fact, is it sufficient evidence if there's hash oil in a cabinet accessible to a toddler? Is that alone sufficient to convict the mom of child endangerment?
It could be, but in this case, when we actually have the husband admitting to smoking it twice that night in the small trailer, using the torch, and the defendant was awake during at least one of those times, so she knew he was smoking that night, and she chose to go ahead and go to bed.
So is there something she could have done other than, I'm having a hard time with the concept that she's responsible for his actions when there's no evidence that he was the one that was in charge of taking care of the child, or that somehow affected her ability to take care of the child.
I would argue that once she goes to bed, he's the parent that's still up and awake. And if
so what happens when they both go to bed? Who's in charge?
I don't know. I don't have children.
I still think that that's a bit of a stretch to say that just because she went to bed, that means that he was in charge if the child was also asleep.
It wasn't a situation where the spouse brought a joint home, hid it away in the cabinet, so the wife didn't know about it. She goes to bed, and then he smokes the joint, and somehow the child gets in and gets exposed to it.
Okay, but in this case, the child was never exposed to it. It seems like, so is it enough if the wife knows that her husband smokes marijuana in the home when the child is asleep? Is that enough to create endangerment?
They both do. So
at the same time? Is there evidence in the record that they both smoked at the same time? And that goes back
to not that evening. But she seemed to indicate that they have used. And Mr. Wilson's trial testimony also says that they have smoked together.
It says knowingly acted in a manner creating a substantial risk to the child's physical, mental, or emotional health or safety. Sort of the state's position is it's kind of, you can look at all the circumstances. Is that
right? And that she would know that these activities are dangerous. And
so the state's position would be that her action here is being a co-parent and a co-resident or tenant of this house, allowing all of these activities to occur while possessing the drugs, the butane, the hash oil, etc., in her house while the child is there. That's her conduct.
And participating herself at times.
Okay.
The state's argument is that it's reasonable to infer that she appreciated the substantial risk in leaving her husband, a frequent drug user who uses a big torch as a lighter, in care and control of...
Substantial risk of what? Substantial risk of fire? Substantial risk of... What's the scope of the danger?
Well, the statute is substantial risk to a child's physical, mental, emotional health or safety.
I guess I'm trying to break it down. I mean, there's one possibility, which is the child could ingest the hash oil or marijuana, I suppose. I mean, I, as a parent, think of Drano. I mean, you put Drano underneath the sink, that's absolutely not what toddlers running around, of course. If the child would have got a hold of marijuana, I'm not sure that that's a terrible danger. If the child would have got a hold of hash oil, frankly, I don't know. I mean, if hash oil is
it was described as a plastic container.
Well, supposing the child drank some of it, would that be a problem, or do we know?
Sticky substance.
Would it be? Was the scope of the risk you're describing the fact that the child might have ingested the hash oil?
Could have. Perhaps if the child had gotten out of bed while they were both
going
sleeping.
to the first video, is it my recollection that you have the sort of the cops arriving on the scene, and he who presumably started the fire with his activities, he's outside, he's gone, and she's kind of just sort of immediately coming out of the house, and she's inhaled smoke, and the little kid is inhaled smoke as well, right?
And they were both covered with black soot.
Yeah, and so, I mean, you know, I think the hard part, the risk seems to be pretty obvious. This was nearly a really, really bad situation, but the problem is attributing the creation of the risk to her or the action to her, right? Isn't that really your issue?
Say that again.
Isn't the problem what is it that she knowingly acted? What knowing act did she do that under the crime of child endangerment? Because she has to have knowingly acted in some way.
I think you can infer he smoked hash oil in the bathroom using the torch while she was still awake. She went to bed knowing that it was likely he was going to use again and use the torch, which is dangerous. Though we don't have expert testimony, she would know the effects of hash oil on herself and her husband, and that maybe he might not act quite as responsibly the rest of the evening if he continued smoking. He clearly left the torch on in some fashion that caused the fire in the kitchen. The state would ask the court to affirm the defendant's conviction. Thank you.
You may proceed. Thank you.
Just for purposes of our record discussion, on page 70 of the trial transcript, the court clarifies what clips were admitted. And he says those were clips of the body camera from Lieutenant McGough, I'm not sure how to pronounce his name, without sound from 8:30:26 to 8:35:21. And the clips were played with Officer Roberts, which I believe was the one in the hospital of the defendant, and those are 7:29:46 to 7:33 and 7:38 to 7:47. Those are on page 70 of the trial transcript. So I think that's pretty clear that the clip in the trailer was without sound, and the clip of her in the hospital was with sound, but is confined to those clips. So I don't think just because it's on those CDs that it was admitted. The first additionally, one was on, I think, the second CD, and one was on the third CD. Furthermore, there wasn't any indication in the record reviewing the district court's findings of fact that there was evidence that Mr. Wilson had told the police that she had smoked hash oil the night before. There was no finding of that. The Court of Appeals also found that there was no evidence that she had smoked, or when she had smoked, that the child was there and she hadn't done it the night before.
It's not so important that the child was there, is it really? Because when you use drugs, it affects a person for a while. So maybe I'm going to smoke pot or whatever it may be outside the presence of my minor children, and then I'm not going to do it in front of them, but I'm going to go join them soon and probably loaded or high. So it really doesn't matter that exact moment, does it?
Well, we don't have any information in this case that shows when, where the child was. Maybe the child was at grandma's for the night, for the week. I mean, it's hard for me to answer that question without facts that we have.
Well, there's evidence that she has used drugs in the past. So I'm just trying to look at it from a perspective of this is not somebody who would be totally shocked by the fact that somebody's using drugs in her home. Isn't there evidence that she has used drugs too?
She has used drugs in the past, but I don't think that can be a basis for a child endangerment when we don't have all the other elements present. We don't have any elements present other than, maybe she's guilty of a possession of marijuana charge, because there isn't anything in the record where the child was present, that she had custody control, that she was acting in a way that put the child at risk, or the child had access to any drug. I mean, there's nothing like that. She just admitted in the hospital that she had previously smoked. I think she said in the home, but really we don't have any other details. So I think that it's very difficult to convict somebody in such a vague admission of having previously smoked marijuana in your house. The other,
So what if she knew that her husband was a methamphetamine user and was smoking that in the house? Is that a different case than this case?
yeah, I think it is. I mean, like the
That because
was it
the risk of something bad happening when using methamphetamine is different, or is the secondhand smoke or something affect the child differently?
Well, for instance, like in the mask case, where I'm sorry, I'm getting my ones confused. The Janes case with the methamphetamine, where there was a lot of people in there. Yeah, I think there was testimony in that case where methamphetamine, the effect that it has on people, and their ability to take care of themselves was the one with the child drowned in the bathtub. Obviously, that's a completely different case and a completely different drug. Not all drugs being equal. That there isn't anything in this case that would show that the marijuana or even the hash oil is as dangerous.
Let's assume that she wasn't a methamphetamine user, though, and that her husband was, and that she allowed him and knew that he used it in the house. Is that sufficient to satisfy the statute?
I think in general, I think it's too general. I think my interpretation is that there has to be some knowingly risk to the child. So if you're allowing him to take care of the child or drive away with the child or something like that, knowing that he's high on methamphetamine and would be a present danger to the child, I think that you need more than just in general. In my opinion, you would need more than just in general, he's a meth user and he's the father. I mean, who's got control, custody of the child at the time, and you have to look at the circumstances for each case. The other thing I would just mention, that Officer Roberts testified at trial that when he was talking to Mr. Wilson, that Mr. Wilson said that he had to correct himself. At first he said that they had smoked hash oil. He said that he had smoked hash oil the night before. So there really isn't anything in here to show that there is any evidence that she had smoked anything. We don't know for sure. Oh, sorry, so my time is up. Thank you.
Thank you. The case of State versus Folkers is hereby submitted, and we will adjourn court. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.